Well, yeah. So I don't mind because everyone on the phone. Yeah. Yes. Can I go into this? Yeah. I got that good, but they're going out.
Good morning. So some vandal has removed all of the markers from this room. So I added a slide very quickly to the deck so that you can access the attendance pin. So we'll give you guys just a second to put that in, since it won't be staying on the board the entire class. All right. So you ready? Everybody good? Does anybody need this read out to them? I'm talking to folks that are squinting in the back. So, okay. All right. So we're going to start today talking about the brown and yellow versus black and white case. So, Mr. Highstand, what I would like you to discuss for us is how does this particular case, as explained in Erie, right? You guys did not read the brown and yellow versus black and white case, but the court in Erie talks about it. So how does the court in Erie use this case to illustrate the problems caused by the SWIFT regime?
It talked about the manner in which corporations or individuals could forum shop in order to gain law that access to law that was more favorable to them simply by crossing state lines in order to gain diversity jurisdiction.
And so specifically, how did the parties in that case manipulate state lines to obtain diversity jurisdiction?
The corporation was originally incorporated in Kentucky. It
sounds weird, but that's right.
I was going to say that's just really bad framing, but they jumped the state line, reincorporated in Tennessee in order to dodge Kentucky common law from being applied to their specific situation.
And why did they want to avoid Kentucky common law?
Kentucky common law was adverse to their cause. What they wanted to do was illegal under Kentucky common law.
And what did they want to do?
I didn't really get all that. It had something to do with luggage gathering and.
Fair enough. Since you say you don't know, let's see if someone else can help you out. Mr. Brown, can you help us out? Like what was it that the brown and yellow taxi cab company was trying to accomplish that Kentucky law would have kept them from accomplishing?
So what I understood was just what the Supreme Court.
Absolutely, right. Like I said, you guys didn't read brown and yellow. So how did the court in Erie describe the situation?
That was a really long way of me telling you I don't know.
Fair enough. Okay. Yeah.
I think they wanted an exclusive contract, and Kentucky statutory law didn't allow that, so that's why they reincorporated to get past the fact that they could, at that point, they could establish an exclusive contract with the railway to dodge Kentucky law.
Ms. Sadler, was it Kentucky statutory law?
No, common law.
Right. And why does that matter?
Because what we were just talking about and how the court's not going to apply common law.
Exactly right. Right. So, and I'm sure that it was just like you misspoke, right? But
that was right.
Yeah, but if it had been a statute, right? If it had been a Kentucky statute that banned these kinds of exclusive agreements, wouldn't have mattered, right? Because under SWIFT, federal courts apply state statutory law, right? but because it's a common law, judge-made doctrine that exclusive contracts aren't enforceable in Kentucky, then by dissolving themselves and reforming as a Tennessee corporation, the brown and yellow created diversity of citizenship, which created federal jurisdiction, which meant they could be in federal court, where the federal court would apply general principles of common law contract. Does the general contract common law allow for exclusivity agreements?
Yes.
You're looking at me like I've grown another head because this question is so easy, right? Yes, you are correct, right? It does. And so by essentially like stepping into a phone booth as Clark Kent and stepping out as a Tennessee corporation, the brown and yellow created a situation where they were going to win their case, where before they stepped into this metaphorical phone booth, they were going to lose, right? Okay, questions? Okay. So, Ms. Holman, in the wake of the conversation that we've just had, talk to me about what it is about Swift that creates forum shopping and renders equal protection impossible. And we'll get to the last piece of this question in a minute. So let's start with those two.
Well, corporate parties could just avoid applying state law and it's by reincorporating under the laws of the new state in order to establish the diversity.
Right? Okay. And so how does that create forum shopping?
When you're shopping around for whatever state is better for you or it's the law.
So how, I mean, I guess a useful question, for those of you who've had BA and for those of you who haven't and just sort of want to think about it, right? What's different about, you know, a corporation reincorporating to create diversity jurisdiction versus a corporation, you know, forming itself or reforming itself, right? Sort of after a couple of rounds of venture capital, maybe reforming itself in Delaware to take advantage of Delaware corporate law. So this question's open to all of you because like we haven't prepped this one. So what do we think? What's the difference? Yeah, please.
Delaware law is specific to corporations. That's their expertise in the nation. They're recognized for that. Any other state law not conforming to Delaware law is going to have anomalies that are not. They're not focused on the business in general.
So are you saying that like we wouldn't have had a problem with the situation in the brown and yellow case if instead of reincorporating in Tennessee, they reincorporated in Delaware?
Perhaps. I don't know the difference between their laws.
Well, I think the point that I'm trying to get at, right, is that I'm not convinced that the substance of why people incorporate in Delaware gives us a good reason to say, well, when they do that, it's okay, but when they do what was done in brown and yellow, it's not okay, right? Because if it is, then in brown and yellow, we don't care if the reincorporation happens in Delaware. But if that's what happens, does that change anything that happened in the case? According to, in terms of how the Supreme Court describes it in Erie. Like, does brown and yellow being a Delaware corporation change anything about how the Supreme Court describes that case? Look, go and look at the extract of the opinion in Erie, right, in the book, where it talks about the brown and yellow case. and replace the word Tennessee with Delaware and tell me if anything else has to change.
Would the cause of action need to be a Delaware cause of action or it be applied in that court? Because if it's a Tennessee state cause of action, then you're still going to apply to Tennessee rules as opposed to if it was a Delaware issue, you're not going to use Delaware state laws to apply it.
I mean, okay, so Mr. Stromer's correct that you do have to replace Tennessee not only as the state of incorporation, but also as the source of substantive law. But assuming that Delaware authorizes injunctive relief to prevent breach of an exclusive contract, right? Assuming that Delaware authorizes these lawsuits at all, do we care? Actually, I'm going to take that back. Even if Delaware doesn't authorize these lawsuits, we don't care. Why not?
Because the issue is that there's diversity, doesn't matter that it's from Tennessee, it's just that it's diversity.
Exactly right. Because the claim is not a Delaware claim. The plaintiff is moving itself. And so the defendant's home is the forum state. And so it's still a Kentucky claim that under Kentucky common law is not authorized, but in federal court would be. And so what we have here is this is what we mean when we talk about forum shopping. Choosing your court changes the outcome of the case. So this is so important that I'm wishing I had my marker again so I could put it on the board for you. Forum shopping. Forum shopping is when choosing the court changes the outcome of the case. Now, that is broader, right? That's broader than just the issue that we see under the SWIFT regime. Okay, so when people talk about forum shopping in the sense of like the Texas Attorney General always filing in Wichita Falls when they challenge a Democratic administration's policy because they know they're going to be in front of a judge who will always rule in their favor, right? Or, you know, sort of the flip side of that, right? The Attorney General of Maryland filing in Maryland to seek relief against Republican administrations because they know they're going to get a judge who is likely to rule in their favor, right? But those are forum shopping as well, right? Because the Attorney General of Texas could file, and maybe arguably should file, in the federal courthouse in Austin. But what's the problem with that? A, there's more than one active judge in the federal courthouse in Austin, so he's not sure who he's going to be in front of. And B, there's a lot of federal judges in Austin who are more friendly to Democratic administrations. So he doesn't have as much confidence that he's going to get the outcome that he wants. So that's why he always files in Wichita Falls. Or Waco. Now there's a relatively poorly regarded Trump appointee in the Waco courthouse. But these are forms of forum shopping as well, even if they are different than the forum shopping that we see under the SWIFT regime. Okay, so Ms. Holman, we're going to come back to you. Can you tell us about how the SWIFT regime renders equal protection impossible?
Well, I think the whole purpose of diversity is for there to be fairness to both parties, but with allowed.
We're not there yet. You're answering a question correctly, but I'm asking a small part of the question, right? I'm asking about equal protection, right? So how is it that the SWIFT regime renders equal protection impossible?
Because it ultimately like prevents uniformity. And as you mentioned, like you're changing the outcome.
Exactly right. Okay. Nothing changes in brown and yellow versus Kentucky state, whether it's in Kentucky state court or Kentucky federal court. Nothing else about that case changes, but the outcome changes. How is that equal protection of the laws? It's legal outcomes depending entirely on what courthouse you're in. Okay. So now, Ms. Holman, I'm going to come back to you because you clearly have this answer and are ready for it. So how is it that these effects are inconsistent with the principles of diversity jurisdiction?
Because the purpose of diversity jurisdiction is for there to be fairness to both parties, but SWIFT allows for to what Brown.
That's exactly right. Okay. So the SWIFT regime drags this notion of avoiding home state bias too far in the other direction. Okay. It affords parties too much control over the outcome of their case. Okay. All right. So what questions do we have here? Do we understand why the SWIFT regime was problematic from this sort of, due process equal protection perspective? Okay. So Mr. Roberts, what, according to the Supreme Court in Erie, right, what is the main goal that they were attempting to accomplish with the SWIFT regime?
I'm confused by the question. Are we on number 16?
Yes.
That doesn't reference Erie. You wanted to.
I added because I wanted to make sure that you guys understood that we're referring to, when we ask what does the Supreme Court say, we're referring to the thing you actually read, which was Erie.
Oh, okay. The SWIFT doctrine was intended to promote uniformity of law throughout the United States. The application of general federal law that contradicted common state law prevented uniformity.
Absolutely right. Okay. So you even answered the second part that I didn't ask you to answer, but that's fine. So the goal is uniformity. We want to make sure that cases are decided the same way when they present the same issue. And exactly what Mr. Roberts said, that what wound up happening is the states sort of clung to their particular versions of the common law. They refused to adopt the general common law as identified by the federal courts. And in fact, the court in Erie sort of goes on for a paragraph or two about how, boy, it sure seemed weird how general common law always seemed to reflect the particular preferences of the judge that was hearing the case. Weird, isn't it? Like, and also weird how whenever there was a local rule that justified abstention from using general common law, weird how the outcome of that local rule also reflected the preferences of the judge hearing the case. Isn't that weird? If you are more interested in this, you can come and talk to me in office hours. I can give you a whole reading list because I wrote a whole comps answer on this. So But yeah, like basically, the idea is if you want uniformity, then you sort of have to like force it on the states because they're not accepting what the federal courts are putting down, right? And so open this up to all of you, right? Do we think that that's likely to work? Mr. Knapp, you're shaking your head. Why not?
I mean, the whole purpose of federalism is for the states to pretty much run themselves, so by having the states pretty much, because they have their own common laws, you're pretty much trying to have them enforce a law they don't really agree with, so.
Pretty much, right? So if you are using the SWIFT regime to create uniformity, then you are undermining federalism. And maybe as a matter of policy, you think that's a good thing. Some days I certainly do. But if you buy into the notion that federalism is an important characteristic of the American system and that it should be preserved, then the SWIFT regime doesn't work. Like it doesn't even accomplish what it says it's attempting to accomplish. Okay? All right. So just to recap, to make sure that we're all on the same page, right? The goal of SWIFT is to create uniformity. The problem with that is that by empowering the federal courts at the expense of state courts, the SWIFT regime created a space where uniformity was impossible. Okay? And so we're gonna be coming back to this. So don't leave it alone, but we're gonna let it go for now. So okay. So Ms. Duncan, I would like you to take the court's statement in. Okay, so you don't get to see DRQ 17 today because apparently I didn't put it in the slide deck. But the court in Erie says there is no federal general common law. Okay. How does federalism relate to that?
Great, so by them saying that, if they were just saying that it focused on the policy impact of allowing federal courts to apply the federal common law and in diversity cases, so encourage the forum shopping since the federal and state courts apply different laws.
And so how does that lead the court to the conclusion that, can't see it, that there is no federal general common law?
It allowed for the plaintiffs to select the law, which was more favorable for their claim.
And so why does the court, but I'm still trying to get, like, why does the court conclude that there is no federal general common law? You have given me all of the premises. I'm asking you to leap to the conclusion.
Because they don't accept that there is, I mean, they don't apply it.
Let me see if I can ask this question because what's happening is you've got all the steps, right? But then I need you to ask yourself, right? If this parade of horribles that the court recites is true, right? And they clearly think that it is, right? Then how do you solve the problems that the court has identified?
I'm not sure.
Okay. let's think about it in terms of what we talked about with this question, right? Because what SWIFT does, right, is it empowers federal courts to determine common law, right? Even where state courts have spoken on the issue. If you are concerned that the federal system is diverging from the state court system on matters of common law, what might you do to bring them back into convergence? If you are the Supreme Court of the United States, right? So obviously, if you're a random knucklehead law student in Topeka, Kansas, you have a very different set of tools at your disposal. But let's suppose that you are one of the 9 wise souls. What might you do to bring federal common law and state common law back into harmony?
I guess you would just have to say which one trumps the other.
And so SWIFT says that federal common law trumps. And the outcome is all these problems where the states go, right? So what do you do next? If you have 2 choices for which one wins, you already said A wins, and you are now identifying all of these problems. What are you going to do next?
Yes, just say that's the one that wins. So if that's the one we have to go by, I'm not sure.
Right, Mr. Stromer, you look like you're ready to jump in.
I think where you're trying to get at is well, Erie is a Supreme Court case. So you would make the ruling pursuant to Erie to get it back to have a line saying that there's no federal common law, apply the state common law. That's the way it is going to be.
Exactly right. Okay, exactly right. SWIFT creates 2 common law systems under the assumption that the states will drift toward the federal common law. And what happens over the 95 years that the SWIFT regime is in place is the states refuse to drift toward the federal common law. And so if your options are create the federal common law or use state common law, and creating the federal common law did not accomplish the goal that you wanted, what option is left? Guys, I've given you 2 options and I've told you one of them doesn't work. What's left?
The other option.
Exactly right. Guys, come on. So if you want to preserve the uniformity goals of SWIFT, but SWIFT itself has demonstrated that you can't push the states towards the federal common law, what you have to do is you have to push the federal courts toward the state common law. How do you do that if you are the Supreme Court?
Can't you vote?
You wipe out federal common law. You say this no longer exists. Okay? All right. So, and to sort of tie this back into the actual DRQ, right? This has to do with federalism because this is not France. And I say that in the sense of institutions based in Washington do not have control over institutions based in Topeka or Jeff City or wherever the capital of Nebraska is, Lincoln. They don't have control over those institutions in the way that institutions in Paris exert control over institutions in Marseille or Nice or Limoges. Okay. All right. So because the central government doesn't control subunits in the American system, because the central government only controls its own institutions, then if you want to converge the two sets of systems, you have to do it through the institutions that you have control over. Okay? If you are interested in this, I actually have a book to recommend to you that I'm not going to bore anyone who's not interested in it over. But basically, like, the idea is that courts exert a lot of control over the courts that they supervise, and they exert almost no control over anything else. And so if you want to accomplish something, you do it by giving commands to the people you control, not commands to the people that you don't. And that is the essential weakness of the SWIFT regime, and why federalism brings the court to where it is in Erie. Okay? All right. So now that you were not expecting this to be a jurisprudence class, a class I also teach, although probably not next year. Ms. Stewart, would you be so kind, if you are comfortable doing so, talking to us about how Erie's discussion of federal general common law reflects the principles of legal positivism?
So I had to look that up.
Which, by the way, right? Absolutely expected, because the book does not tell you what legal positivism is. And B, here we are back again with a question that Professor Bahadur expects you to walk in getting wrong. Okay, so with that in mind, right, now that the stakes are much lower, because if you got it wrong, you're just meeting expectations, right? So go ahead.
My understanding of it was the court seems to reject legal positivism to the degree that the authority creating the law is federal judges, but it seems to accept it to the degree that the states are.
So, Ms. Stewart, since you say you looked this up, I'm going to follow up with one question, but then probably I'm going to talk a little bit about these things that you cannot be expected to know. But what is legal positivism as a tool of philosophy? What is it sort of put in opposition with? You know?
Well, I don't know.
Okay, fair enough. Ms. Morgan?
It's usually put up against like natural law. So natural law is this idea that it's like a social or like moral code that just exists. It's like generally understood. And legal positivism is saying that like law is man-made. It has to come from a source.
Right. Exactly right. So natural law theory is sort of the oldest school of Western legal philosophy. It's built around this notion that you guys do not need to be taking notes on this. This is all just asides to build up to the answer to this. Okay. Like I'm seeing fingers flying, and I'm like, oh my God, no. So natural law theory is, as Ms. Morgan says, it's the notion that law derives from moral principles that exist sort of universally and without any sort of human action required. So, the basic idea behind natural law is like, even if Homo sapiens went extinct tomorrow, murder would still be wrong. Okay, so the idea behind natural law theory is that these are legal principles that don't depend on us and our choices, right? These are legal principles that apply to aliens, that apply to situations where there's no no living creatures whatsoever, right? That's the idea behind natural law theory. Positivism says, well, wait a second. What is the point of law when there's no people? And so positivism suggests that law comes from us. It comes from our decisions collectively as a society. And we're not going to go down, like, if you're really interested in this, take jurisprudence. Please take it from someone other than me. I liked teaching it, but it's also because I essentially ignored the positivism and natural law debate. And we talked about things I was interested in that were completely different. But the idea behind positivism is law is posited, right? Law is defined. Law is not discovered. And so the question in Erie relates to who gets to define the common law. Okay. If Erie was approaching this through a natural law lens, then Erie would sound more like this. And I'm spitballing this off the top of my head, so I make no promises as to the quality of this. But Erie sounds something more like this, right? Assuming that we still want to reach the same outcome, okay? The identification of principles of law that govern certain questions relies upon the application of universal moral principles. However, which principles apply in a given case may be disagreed upon. And the genius of a federal system is that these disagreements are allowed to flourish. And we allow them to knock about in the marketplace of ideas and persuade one another of which universal principles should control. Under the SWIFT regime, we short circuit that marketplace of ideas by empowering federal courts to identify the universal principles that animate legal questions. And so we are choosing to empower the creativity of the American system and empower state court judges to identify universal legal principles. By declaring that there is no longer such a thing as federal general common law. Does that sound anything like what you guys read? I hope the answer is no. And that's because Erie is approaching this through a positivist perspective. Brandeis is widely regarded as one of the great positivist thinkers of the American bench. Okay, and also the fact that he extensively quotes Oliver Wendell Holmes, who's like the father of legal realism, which is like positivism plus skepticism that law actually matters. These are all sort of evidence that the natural law approach is being disfavored. Okay. So do we understand? Do we feel like we've got a grip on how positivism is operating in Erie? Even if, and I want to be clear, right? Even if you feel like positivism doesn't make any sense, okay? And that's largely because in order for it to make sense, you need to do a lot more reading about it than I have given you. But even if positivism doesn't make sense, do you see how, if we grant the argument of positivism, how it fits into what Erie's doing? Yeah, okay, good. All right, so Ms. McHenry, I'd like to talk to you about the concurrence from Justice Reed. There's only one sentence of it in the book, and that's all we need for right now, right? So why is it, and it may be helpful to think back to Tuesday's conversation when you answer this. Why is it that Justice Reed goes out of his way, writes a separate opinion to make the point that federal courts have control over procedural law, even though the Erie case has nothing to do with the substance procedure divide?
All I really wrote on this one was that they both have to do with, like, if it's procedural, then you're applying it depends on which federal or state law that you're applying.
Well, let's think back to our discussion on Tuesday, right? So, Ms. McHenry, what are the sources of state law that could come under the Rules of Decision Act?
Statutes, state constitution, and the local rules,
And what else? Because this is could, not does.
and common law.
And common law, right? Okay. And what rules of procedure do federal courts apply under the SWIFT regime?
State.
Exactly right. Okay. And you guys may or may not have picked this up, but there's actually a separate statute, separate from the Rules of Decision Act, called the Conformity Act, that requires federal courts to use the rules of procedure of the state in which they sit. Okay. So, Ms. McHenry, given what I've just told you about the Conformity Act, what do you think the Rules Enabling Act does to the Conformity Act? Okay, well, what did I just tell you the Conformity Act does? I just said it. I promise it's not that hard. Just repeat the words back to me that I just said.
I know. I kind of spaced out when you're explaining the Conformity Act.
It happens. It happens. No worries. No worries. Mr. Harrison, can you help her out? What does the Conformity Act do?
I spaced out too, but.
No worries. No worries. All right. Well, I'm sorry?
That's not the rules enabling act.
No, the Conformity Act. Fuck.
The Conformity Act requires that federal rules of civil procedure be kind of set aside for the local rules of procedure.
You've overcomplicated it.
Okay.
Under the Conformity Act, there are no federal rules of procedure. You only use state rules of procedure. So, Ms. McHenry, back to you. What does the Rules Enabling Act do? We talked about it on Tuesday.
It just announces that the federal courts will now have their own system of procedure.
And so now let's put it together. Okay. What does the Rules Enabling Act do to the Conformity Act? Exactly right. Exactly right. Got it in one. Okay. So given the timing here, right? We talked about this on Tuesday. Given the timing here, what do you think Justice Reed is doing by asserting federal power over procedural law? This one's like, this is the next step beyond what you might have prepared. So like, if you're not comfortable with it, it's okay to pass.
I don't know, more than just reiterating.
Okay, well, reiterate for us so that maybe because, I space out too. Now, I'm listening to you guys when you talk, but then I have to clear the buffer so that I can listen to the next thing that you say. So remind me what you said.
So the Rules Enabling Act overrules the Conformity Act.
Yep.
And Justice Reed is reiterating in his last sentence the concurrence that just that there are federal procedural rules.
Well, let me.
This might be not the right thing at all, but I was just thinking that he's setting up for a conversation of a potential problem, like he's foreseeing that our next case that we're gonna read is gonna happen. So that's why I put it down. What's he doing? Why is he saying this? Like, well, he's foreseeing that there's gonna be a new case. We do read that new case and question after question 20.
Well, I think you're onto something there.
But I don't.
So let me see if Mr. Stromberg, maybe you can help me out with this a little more. If you are, let's suppose, for the sake of argument, that you are a litigant who has a case pending in federal court as of September 16th, 1938, when the federal rules of civil procedure go into effect. Let us suppose further that let's suppose that you're in California, right? So we're dealing with code pleading. And let us suppose that you have a motion to dismiss for failure to adequately plead pending on September 16th. And after September 16th, the federal court issues a ruling that says pleadings are subject to Rule 8, plain and simple statement of the facts. We no longer utilize field code pleading. This is, the prior, the motion was well taken at the time that it was filed, but the new rules are in place. And so we are using the new rules, and the motion is due to be denied under the new rules. What might a grounds for appeal be for you?
The grounds of appeal.
And well, okay, I'm gonna tell you one grounds of appeal and then take them away and ask you to identify a second one. Okay, one grounds of appeal is that in fact the court should not have used the new rules, right? Because the motion was pending prior to the enactment of the new rules, that they should have used the old rules, right? But assume, for the sake of argument, that grounds of appeal is foreclosed. Okay, what other grounds of appeal might you use?
I don't know what the actual category would be, but my issue would be is that I would want the federal rules to apply, not the state. That would allow me to have my motion
Well, no, the state rule is what gets your motion granted.
granted.
So you want
that.
that to apply. What argument might you make to suggest that the state rule should apply even in the face of the Rules Enabling Act?
This case. Theory.
Okay, why?
Because there's not a distinction. Therefore, I would say that all procedure, there is not a difference between procedural or substantive law. Therefore, the state law should govern.
But we have this federal statute that says that federal courts apply federal procedure. And wouldn't that preempt? Yes, Ms. Caballeros.
Because we have all these, how they were saying that, so we're gonna apply the state law,
Mhm.
but then we're gonna use federal procedure to dictate how the case is done. So it's it would kind of make sense to me if we're gonna use state procedure when we're applying state laws, and then federal procedure when we're applying federal law. So then it gets kind of confusing, because what if the state law requires a response in 15 days, but the federal law gives you 30 days, and so.
Okay, we're gonna get to that. But you're absolutely right that these are issues that arise, right, through the Erie doctrine, and we're gonna absolutely get to that as we work through the chapter. So, Mr. Hyacinth, you get the last word, and then if you don't get it right, I'm gonna give the game away. So
We'd argue it's a substantive law instead of a procedural law, because if it's substantive, we're going to use the state law, and that's what we want.
I mean, I think the words federal rules of civil procedure sort of like that. I mean,
according to the Supreme Court.
So if I'm in the situation that I described to Mr. Strummer, where I want the state rules to apply, I'm going to argue that the Rules Enabling Act is unconstitutional, that it exceeds the exercise of the judicial power or of congressional power, since it's a congressional enactment. And so Reed's concurrence is intended to close that door. Okay, he is signaling to litigants, don't bother trying to kill the rules. Okay. All right. So, and as Mr. Strummer points out, on Tuesday, we will actually, we will begin actually discussing sort of the effects of Erie plus the development of the federal rules of civil procedure and how they've created this substantive procedural divide and how that has played out over the course of the last 85 years. So with that, we're going to see you guys on Tuesday. So take care. And, don't do anything I wouldn't do. That doesn't close the door that much. So, all right. Take care, guys.
I kind of like. Yeah.
Yes. One second.